Welcome to everyone on this cold January afternoon. We have a great presentation for you today. This is a topic that is near and dear to my heart because it is an area of my practice that I focus on quite a bit. So we're going to be talking today about trends in employment litigation. I'm joined by my colleague, Hannah Redmond. Hannah and I work as a team on many of these cases, and we're going to talk about some cases today that we have worked on for our various healthcare clients. All right, so why don't we get started here, Kathy, with the agenda. We're going to talk generally about discrimination, harassment, retaliation under both federal and state law. There have been a couple of recent legislative updates that we think are of particular importance to this area. We're going to talk about the New York State Human Rights Law harassment standard, which I think has bothered many people or at least caused a lot of confusion for many employers over the past couple of years. We're going to talk about some expansions of employee protections that have recently occurred. And as we go, we're going to sprinkle in some case studies that illustrate some of these points. So to get us started, Hannah is going to walk through some of those legislative changes. Hannah, take it away.
Thanks, Adam, and welcome everyone. Thanks so much for joining us today. Kathy, can you advance? Thank you so much. So we're going to start very basic today with some refreshers and fundamentals to acclimate everyone to the topics that we're talking about today, that being discrimination, harassment, and retaliation. Under both state and federal law, discrimination and harassment are, of course, prohibited based on any protected characteristic. And in the slides immediately following this one, we're going to talk about what those protected characteristics are under both state and federal law. There is significant overlap primarily in the major protected characteristics that we often see claims being based upon, but it's important to understand that there are differing characteristics that are protected under both state and federal law. Both state and federal law also prohibit retaliation for engaging in any kind of protected activity. And in its most basic, protected activity is when somebody tries to enforce their rights to be free from discrimination and harassment. So when they try and assert their rights under the federal and state equal opportunity employment laws that we're talking about today. The classic example of protected activity is an employee or an applicant or another person in the workplace who makes a complaint of discrimination or harassment. That is the classic example of protected activity, but it is, of course, not the only example of protected activity. So other things like requests for religious accommodations or disability-related accommodations, requests for leave, and even just participating in an investigation of somebody else's complaint of harassment or discrimination. All of those activities are protected, and employees who engage in that kind of activity cannot be retaliated against. So no adverse action can be taken against them because of that action. And then we're going to talk a lot about harassment today. We use harassment, that phrase, as a catch-all, but it's important to understand that there are different kinds of harassment claims. And the three more common claims that we see are hostile work environment, quid pro quo, and stereotyping. Hostile work environment is something we're going to talk about in greater depth in just a little bit here, but it's essentially the idea that somebody claims they're being subject to less preferential or worse treatment than somebody else because of their protected characteristic, that they're subjected to worse terms and conditions of employment because of their race or their sex or their age or some other protected characteristic. Quid pro quo harassment is often thought of as this for that harassment. It's a trade. It's more easily identifiable than a hostile work environment claim because it occurs when somebody with managerial authority, such as a supervisor who has the authority to provide job benefits, tries to or does trade a sexual favor for a job benefit. So, for example, a supervisor who says to a subordinate employee, if you do fill in the blank sexual favor for me, I'll make sure that your PTO request was granted, or that you get that promotion you wanted, or that your raise becomes effective sooner than later. So that kind of thing. It's easier to spot than a hostile work environment claim. And then finally, stereotyping is another form of harassment. And this occurs when preconceived notions about how somebody of a particular protected characteristic should look or act or dress, or what position they should have, what duties they should perform. And sex stereotyping occurs when those preconceived notions don't match up with what the person actually does, what job they perform, their duties, how they dress, how they speak, how they look and act. And for our purposes today, a classic example would be the idea that nurses are female and doctors are male. That would be an example of unlawful sex stereotyping. Next slide, please, Kathy. We have a number of laws under the federal side of things that collectively prohibit discrimination, retaliation, and harassment on a number of protected bases, starting with Title VII of the Civil Rights Act of 1964. That law prohibits race, color, religion, sex, and national origin discrimination, harassment, and retaliation. The Age Discrimination and Employment Act prohibits discrimination and harassment on the basis of age. For purposes of federal law, that's 40 and older. That's a little bit different than under state law where it's 18 and older. The Pregnancy Discrimination Act and Pregnant Workers Fairness Act prohibit pregnancy, childbirth, and related accommodations. It requires some accommodations and prohibits pregnancy discrimination. And then we have the Americans with Disabilities Act, which of course prohibits disability discrimination, and the Genetic Information Non-Discrimination Act, Immigration Reform Control Act, and Equal Pay Act, which similarly prohibit discrimination and retaliation, respectively, on the basis of genetic information, citizenship, and immigration status. And then the Equal Pay Act actually falls under Title VII, and it requires that employees of all sexes be paid the same without respect to their sex. So we have a little bit of a legislative suite under federal law, a few different statutes that we're dealing with that collectively prohibit discrimination on these various bases. Next slide, please. And then under New York state law, we have the human rights law, where we're dealing with one statute different from federal law, where we have a bunch of different laws. But within the human rights law, all of these different protected characteristics that you see on the slide here are protected under the human rights law. As you can see, even just from a quick comparison of this slide versus the prior slide, there are far more protected characteristics that are recognized under New York state law as compared to federal law. And like I said at the outset, there is considerable overlap, particularly in the more common types of claims: age, race, religion, sex, disability. But if you look at the right-hand portion of this slide, there are some different protected characteristics, such as marital and familial status, reproductive health decision-making, domestic violence victim status that we didn't see explicitly recognized under federal law. It's important to know that when we're talking about these protected characteristics, particularly when we're talking about New York state law, the law is always changing. We're constantly seeing new protected characteristics added to this list. For example, citizenship and immigration status was added to the New York State human rights law as a protected characteristic in December of 2022. And then even for protected characteristics that have been recognized for a number of years, such as domestic violence victim status, we see additional protections being added in. So domestic violence victim status has been a protected class for a number of years with respect to employment discrimination claims, but additional protections were added in May of 2022. So that's a protected class for purposes of a public accommodation claim, education-related claims, and housing claims. Next slide, please. For a quick overview of the claim process, an employee who believes that they have been discriminated against or harassed or retaliated against have a few different avenues of relief available to them. They can file a complaint through an administrative agency, or in certain circumstances, they can file a claim in court. For claims under the New York State human rights law, employees have the option to file with the Division of Human Rights, which is the state's administrative agency that's tasked with investigating and helping to eradicate discrimination and retaliation in the workplace, or they can go right to state court. So they have their option there to go an administrative route or to state court. The Equal Employment Opportunity Commission is the federal administrative agency that, much like the Division of Human Rights, investigates complaints of discrimination, harassment, and retaliation. But unlike the Division of Human Rights, employees who want to pursue their claims under federal law or in federal court do need to first file with the EEOC. So there is an administrative exhaustion aspect when employees are trying to enforce their rights under federal law. But the EEOC and the Division of Human Rights and the New York City Commission on Human Rights largely operate the same. They're a little bit less formal than litigation. The claim is made typically through a cost-free process. The complaint is filed to the administrative agency. An investigator is assigned who then takes on the case and investigates the allegations. The employer has an opportunity to respond. And then if the case proceeds through the initial investigatory phase, it ends up in a hearing. Next slide, please. So we were talking about protected characteristics under the human rights law, the state human rights law, just a few slides ago. And as I mentioned, we're constantly seeing the list of characteristics that are protected evolve. And that's best highlighted by recent legislative changes to the New York City human rights law. So this, again, applies only to employees who are working in New York City. So for our clients and friends on the line who have operations within New York City, employees working in New York City are now protected on the basis of height and weight. Height and weight have been added to the New York City human rights law as protected characteristics, and employees cannot be discriminated against or harassed because of height and weight.
Hannah, if I could cut in for just a second.
Absolutely.
This is one thing that we see regularly. The New York City human rights law will be amended to add a protected characteristic or some additional protection. Shortly thereafter, we will see that expansion to the state human rights law. So this may be an indication of where the state human rights law is going next. So even though it's currently limited to New York City, those employers throughout the state should be aware of this.
Absolutely. And that's true with legislative changes we see out of the city in general. We just saw this with pay transparency as well, where the city gets there a little bit faster than the state, and statewide legislation follows shortly thereafter. So definitely something just to have on your radar, and we're certainly going to be watching it. There are a few exceptions under the New York City human rights law when the action is required by law or regulation, or when the Commission on Human Rights permits such action. Height and weight can be considered in employment decisions. That is fairly limited. So for example, if there's a physical fitness requirement that has a weight limit required by law or regulation, that would be something that falls within the exception. Next slide, please. Flipping back to the New York State human rights law, we have a change to the statute of limitations for filing an administrative complaint with the Division of Human Rights. So effective February of 2024, complaints can be filed with the Division of Human Rights for up to 3 years for any claim, not just sexual harassment. So if you recall, in 2019, the law changed a little bit so that sexual harassment claims could be filed for up to 3 years, as opposed to the 1-year statute of limitations that was applicable to all other forms of discrimination harassment claims. But now this recent amendment is making it such that all claims can be pursued with the division for 3 years. Really important to note, though this is a notable change, it's not too material from an employer's perspective, because the state law statute of limitations to file in state court has been 3 years since the inception of the human rights law. So employees now just have a longer period of time to file with the administrative agency, but we're not expanding the total period of time that their claims remain live. Next slide, please. These claims that we're talking about today, we're talking about both claims that are filed in court and administrative claims. The vast majority, regardless of whether they're at the agency level or they're in court, are either resolved through dispositive motions and motion practice, or they're settled by mutual agreement of the parties. And so when we're talking about settlement agreements of claims that involve discrimination, harassment, or retaliation, the general obligation law does impose some particular requirements on what provisions can be included in a settlement agreement, particularly as it relates to confidentiality and non-disclosure. It's really important to understand that when we're separating an employee and there is no claim that's involving discrimination, harassment, or retaliation, these rules do not come into effect, and standard confidentiality and standard non-disclosure provisions can be utilized. It's only when we're settling a claim of harassment, discrimination, or retaliation. The law does specifically reference the human rights law, but it's not limited to claims that arise under that law. And these rules apply to settlement agreements between employers and employees, applicants, and independent contractors, so fairly broad there. And what the law says is that an employer can't prevent employees from disclosing the underlying facts of the claim or the cause of action that they're trying to pursue unless confidentiality is the employee's preference. The employee has to affirmatively say that they prefer that confidentiality be maintained. Next slide, please. Employees have up to 21 days to consider the confidentiality and non-disclosure provisions. This is a change. We previously thought that employees could not waive the 21-day. They couldn't execute before that 21-day period ended. We now know that they can. The 7-day revocation period remains unchanged. And then finally, very importantly, to obtain an enforceable release of claims, there are certain provisions that cannot be included in settlement agreements. And given that the release of claims is really, it's the whole ballgame for the employer, that in addition to the discontinuance of any claim that might have already been filed, is to get this release so that future claims cannot be made. To have an enforceable release, a settlement agreement that is covered under this provision of the General Obligations Law can't include a provision that requires the complainant to pay liquidated damages or to repay or forfeit the settlement payment for violating a non-disclosure or a non-disparagement clause. And then finally, the settlement agreement can't contain an affirmative statement that the employee represents they were not in fact subject to discrimination, harassment, or retaliation. And I'm going to turn it back over to Adam.
Thanks, Hannah. A couple of notes. First of all, if you are not subscribed to Bond's Labor and Employment blog, I would encourage you to do so. We have articles on all 3 of those different legislative changes, which were posted shortly after the changes took place. So if you followed along with the Bond Labor blog, you would have already known all of those things. The other thing I would note is that I would make sure that you are confirming your settlement agreements don't include these liquidated damage or penalty clauses. They used to be very common, and this change is relatively recent. So it's a big deal. If you include this in one of your settlement agreements, the release is no longer going to be valid based upon the change in law that happened in November. So this is an important change. Thank you, Hannah. Okay, next slide. Interestingly, every year, the Division of Human Rights provides an administrative agency update that looks at statistics that look at the different claims that have been filed over the past year so that employers really can get a picture of where these claims are coming from, what the subject matter is, et cetera. So we already have the administrative report from the Division of Human Rights from 2023, and there's some interesting things that I wanted to point out. First of all, 77% of Division of Human Rights complaints involve employment discrimination or retaliation, the kinds of claims that we were just talking about. 11% involve public accommodation complaints, and as healthcare providers, I'm sure that you have seen these complaints before. You have an individual who files a complaint with the division that says, I was denied medical care, or I was kicked out of the hospital because of my protected characteristic. A couple of important things about those claims. To sustain one of those claims, a plaintiff has to show a couple of things. One, that the that the hospital medical provider had an intent to discriminate on the basis of a protected characteristic. And secondly, that an actual benefit was withheld. So you see this sometimes when some people don't want to be discharged from a facility. The facility wants to discharge the individual, they do, and then there's a subsequent claim that you denied them a public accommodation because of some protected characteristic. That makes up 11% of all claims that were filed in 2023. The remaining 12% include housing and other types of educational claims. Next slide, please. Interesting statistics regarding where or the type of claims that were made. The most common types of claims, the top 4 were the same in 2023 as they were in 2022. Disability claims are the most prevalent type of discrimination claim that is made to the division. I would note that that includes 2 different types of claims. failure to accommodate claims, as well as disability discrimination claims. So that might be one of the reasons why it's number one. Retaliation claims, which encompasses all types of alleged discrimination and protected activity, would be number two. Race, color, sex, and then the others, as you would imagine, age, national origin, and religion. We did see an increase in religious discrimination claims this past year, which overtook national religion, which is worth noting. Next slide, please. Okay, now we're going to move on to talking about harassment. We're going to focus on the state's sexual harassment law and what we've been observing over the past year with the enforcement of that law. But I'll start off by talking about the federal harassment standard. So for many, many years, both the state and federal law protected against severe or pervasive conduct. So that was the threshold that conduct had to meet before it would be legally actionable. The federal law still has this severe or pervasive standard. And as you can see here, severe represents the minority of hostile environment claims, and it deals with, it's self-explanatory, the severity of the conduct. So a single incident, if it is severe enough, would constitute severe conduct and therefore a hostile work environment. This can include sexual assault, touching, physical violence, hate speech, quid pro quo. If it rises to a particular level of severity under federal law, it would be considered severe and actionable. Similarly, pervasive is the other way that you can establish hostile work environment under federal law. That involves more repeated conduct. It's based on the totality of circumstances. Importantly, some conduct, when a plaintiff is trying to establish pervasive conduct, they can sometimes reach into conduct that would otherwise be time barred to say that it is a continuing violation over a long period of time, continuing and a continuous process of harassment. So that is how you'd establish pervasive conduct under federal law. Next slide. Here is what we want to focus on for the purpose of this presentation is the state's sexual harassment standard and how it's been interpreted under state law. So as I'm sure all of you know, in 2019, the state lowered the threshold for what constitutes sexual harassment under the state human rights law. So conduct is now unlawful if it subjects an individual to inferior terms, conditions, or privileges of employment. And here's the important thing. The conduct has to rise above what a reasonable person would consider a petty slight or trivial inconvenience. Now, the federal standard is severe and pervasive conduct. The state standard is petty slights and trivial inconveniences. As you can imagine, the state standard is lower. The problem that we've faced and the problem we've seen with the Division of Human Rights is they have no idea what that means. So we're going to talk about what we've heard from the division and what we've been seeing. Next slide, please. Unfortunately, the law doesn't define petty slights or trivial inconveniences. And so what the division has been doing is in almost every case where a sexual harassment has been alleged, they are issuing probable cause determinations because they don't know what it means. So we have had conversations with regional directors, and we have asked, what is the division interpreting petty slights and trivial inconveniences to mean? Unfortunately, the response we've gotten is that the division considers at this point anything to rise to the level of petty slights or trivial inconveniences until there is some case law from either administrative law judges or from courts that provide more explanation or more information about what that means. I know that one of my colleagues had a call with one of the regional directors in which he asked the regional director, if you are going to issue probable cause determinations in every single case where sexual harassment is alleged, why would we even participate in the investigation process? And the regional director responded by acknowledging that that is a difficult situation to be in for an employer, but basically told us that we had the option to settle it or just move forward. This is obviously ridiculous, and it completely ignores the body of case law in New York that talks about an employer's obligation or an employer's liability only when the employer condones, approves, or accepts certain conduct. So this is something, unfortunately, that we've been seeing in the division. If any of you have gotten probable cause determinations recently, I'm sure you've seen the standard language that the regions are putting into the determinations that essentially say we don't know what this means, but there's enough alleged here to get a probable cause determination. It's unfortunate, but that's where we are. Next slide, please. As you can see, early dismissal can be difficult. That's what I was just talking about. Issues of fact are common, and this is primarily because we don't really know what that standard means. Now, it's not all bad news because we are starting to see cases that are bringing that petty slights and trivial inconveniences standard a little closer to severe and pervasive, and Hannah is going to talk about a couple now. So Hannah, go right ahead.
Thanks, Adam. Thank you, Kathy. You read my mind. So we have a few case studies. Importantly, we have two cases. They're both from the Southern District of New York, and they were issued at the end of last year. So they're very recent. And in both of these cases, as Adam said, we see the court starting to explore what is a petty slight. What is the new standard? What does it mean for something to rise above a petty slight or trivial inconvenience? We do have to be mindful, however, that these are federal courts interpreting questions of state law. So while it is the most helpful guidance we have right now, and it's very good precedent, and it's very helpful to understand the contours of this new standard, that it remains possible that a state court would have a different interpretation of this new petty slights and trivial inconveniences standard. So turning to our case studies, in our first case, we had a plaintiff who was an African-American nurse, and she alleged that she was harassed on the basis of her race under both state and federal law. Her claims were primarily relating to her relationship and her interactions with her manager. She claimed that her manager denied her time for vacation, but allowed other staff members to take vacation around the same time. She alleged that her manager made two race-related remarks to her, one in 2018 and one in 2019. And interestingly, in this case, it was the same comment. The specific comment that was made is the nurse manager said to the plaintiff that she came across as an angry Black woman. She made that same comment to her twice, once before the amendments to the New York State human rights law became effective, and once after the amendments became effective. So that's a little bit of an interesting fact in this case. And then finally, the plaintiff alleged that she was being subject to higher performance expectations than her colleagues, and that her performance was being scrutinized more heavily. Next slide, please. The employer moved for summary judgment in this case and asked that the court dismiss all of the claims, both state and federal. And the court separately analyzed both the state and the federal claims, given that we have two different standards for what is harassment under each of those bodies of law. With respect to the federal discrimination and harassment claims, the court held that infrequent episodic comments don't rise to the level of severe or pervasive because they're very few in number and they're not occurring over a long period of time, so there's not that pervasiveness. This is often referred to as the stray remarks defense, and it's just what it sounds like. There's only a few comments. They occurred, only very incidentally. And then the court said the remaining conduct that the plaintiff was complaining about was race neutral. So in this case, with respect to the paid time off request, the employer was able to present evidence that other African-American employees were allowed time off around the same time, and that plaintiff had particular circumstances given her schedule, and that's why her time off request was denied. And then the employer was also able to demonstrate that all employees, regardless of their race, were subjected to the same performance expectations. And so the court said that these two comments, even though they were race-related, the rest of the conduct was not race-related, and so we don't have this level of seriousness, severe or pervasive, that wasn't met. Turning to the New York State and New York City claims, which were analyzed together, the court did find that the plaintiff was able to demonstrate that she was treated less well than other employees. But crucially, she wasn't able to show that that less well treatment was because of her race. So because she was missing that crucial causality between her protected characteristic and the treatment that she was complaining about, she couldn't prove that she was subject to harassment. The court also said, and this is our most important note from this case, it's where we're going to focus on, is that the two race-based comments that the plaintiff was complaining of amounted only to petty slights. And so here we're seeing a court suggest, Kathy, can you go to the next slide? So here we're seeing a court suggest that the stray remarks defense that has been recognized under federal law for a long time may remain viable under the amended state harassment standard, even though we know that it's a lower threshold. We know that it's easier to state a harassment claim under the human rights law than under Title VII. This decision is lending some support for the notion that the stray remarks defense remains alive and well. And again, it was based on the particular facts of this case. So that could change in a different case, but we're seeing, as Adam said, the state harassment level move up a little bit in our minds. Next slide, please. So we have another case study similarly out of the Southern District of New York. Here, the plaintiff was a CT tech in a same-sex marriage, and she complained that one of her male coworkers was bullying her and that he made physical contact with her on 2 occasions. Her complaint related to non-sexual physical contact. There were 2 occasions during which he bumped into her or stood too close to her so that she had to rub past him to get by. She filed a complaint saying that she was subjected to harassment on the basis of her sexual orientation. And looking at those allegations, the court said that these also were insufficient under the less demanding petty slights and trivial inconveniences standard. And the court again focused on that lack of causation, that there was no evidence of sexual orientation related animus. Next slide, please. Importantly here, the court went even further and it said, even if plaintiff had presented evidence that there was animus on the basis of her sexual orientation, her claim would still fail because there was no evidence that the conduct she's complaining of rises to more than a petty slight or trivial inconvenience. So her claim that she was bullied or that the male coworker wasn't a great teammate, didn't help her out, didn't have her back, and that he bumped into her on 2 occasions, those complaints were nothing more than petty slights and trivial inconveniences, which is highlighting for us that unpleasant conduct and personality conflicts remain below the state standard for harassment. Next slide, please. So, as Adam said, we don't have a definition for what is more than a petty slight or trivial inconvenience. So we're kind of backtracking using court decisions to say, okay, we don't know what is a petty slight or trivial inconvenience, but we're starting to understand what it is not. And so what it is not harassment under the new state standard are personality conflicts, proper supervision and management, in other words, holding employees to uniform expectations for performance and conduct, unpleasant conduct unrelated to a protected characteristic. So even if it's a decision that the employee doesn't like, or it's a decision that they would have made differently, that is not harassment. And then again, the stray remarks defense is potentially viable under state law.
Hannah, thank you. I think that it's not potentially viable, it is definitely viable. And I can tell you that in my position statements, when I'm defending sexual harassment claims to the state division or the city division, I'm going to be citing these cases to say, look, you can't just PC every single sexual harassment case anymore. Look, courts are starting to define for us what it means. This doesn't rise to what the courts are saying. So these are great developments in the area of employment litigation and in particular sexual harassment claims under the New York State human rights law. Okay, next slide, please. I talked a little bit about COVID vaccine mandate litigation during our first session of this series, but I want to dive into it a little more in detail here. As you all know, New York State and its healthcare vaccine mandate went away on October 4th. The CMS vaccine mandate also was withdrawn in August of this year, of 2023, I should say. So we're no longer dealing with a vaccine mandate, but of course, who knows what's going to happen in the future. Next slide, please. What we saw a lot of were claims of religious discrimination based upon the vaccine mandate. The standard fact pattern is healthcare employer requires vaccine pursuant to mandate. Employee has a religious objection and requests an exemption to that mandate. Employer denies the religious exemption and terminates the employee. Employee files a claim against the employer. We saw so many of these claims both at the administrative agency phase and in actual litigation. Next slide, please. Employers defended these claims on several grounds. They said, first of all, granting an exemption would result in a violation of law because the New York State healthcare vaccine mandate did not provide for religious exemptions. It also would cause an undue hardship because of increased health and safety concerns and the impossibility or unavailability of remote work. In the case of nurses who were in person, you had the additional argument that allowing these nurses to work remote would eliminate an essential function of their position and therefore would constitute an undue hardship on that ground as well. In most cases, and I say most, claims were dismissed by the administrative agencies and the courts. Next slide, please. And it's interesting, I've had to do a lot of work in this area. Within the course of less than a year, we saw 9 federal court decisions granting healthcare employer motions to dismiss these claims. They all had the same rationale in them, which was that the healthcare employer could not possibly grant the religious exemption without violating law, which was necessarily an undue hardship. Unfortunately, the state courts were not and have not been as consistent in applying that rationale. Some state courts have held that, well, we don't know at the motion to dismiss phase whether or not there was potentially some accommodation that you could have provided to this individual that would allow them to stay employed while remaining unvaccinated. Those cases are currently making their way through the appellate divisions. I will be arguing one next week in one of our appellate divisions. So it's yet to be seen whether we get a consistent and clear standard from the New York State courts. But it's interesting to see that the federal courts in all departments, Southern District, Eastern District, Western District, Northern District, were all consistent in applying the same standard and dismissing those claims. Next slide, please. And Hannah, I'm going to turn it over to you here.
Great, thank you. So quick refresher on religious accommodations and the undue hardship standard. If you remember back to the middle of 2023, the Supreme Court issued a decision in the Groff versus DeJoy case that fundamentally changed the way that we think of accommodation requests and the way that accommodation requests need to be handled in the context of religious discrimination. We're talking about religious accommodation requests in this case. So quick refresher on the facts. In Groff versus DeJoy, we had a Christian employee who requested not to be scheduled on Sundays because that was his day of observance. The employer didn't grant that accommodation. The plaintiff eventually resigned and then sued the employer for religious discrimination, claiming that his request for accommodation not to be scheduled on Sunday was a violation of Title VII. The employer moved to dismiss and was successful. So the lowest court said that there was no religious discrimination. The plaintiff appealed and the Third Circuit affirmed, saying, we agree with the district court, there was no religious discrimination here. And those 2 lower court decisions applied the undue hardship analysis as we previously understood it before the Supreme Court became involved in this case. So that undue hardship was that an employer could deny a request for a religious accommodation as long as the burden of the requested accommodation was more than a de minimis cost. And this was a very low threshold, vastly less demanding than the undue hardship that we think of in the disability context. It really required the employer to show a little more than there's some impediment to providing this accommodation. It doesn't have to be a serious impediment. It doesn't have to result in the total change of our operation or a significant financial expense. It just had to be something more than de minimis. When the Third Circuit affirmed the decision in Groff that there was no religious discrimination, the employees appealed again to the United States Supreme Court, And the Supreme Court reversed and gave us a new standard for undue hardship in the context of religious accommodations. It rejected the de minimis cost analysis and instead said that to establish undue hardship, employers now have to show that granting the requested accommodation would result in a substantial increased cost in relation to the conduct of its particular business. And we didn't get a ton by way of illustration of what this substantial increased cost will look like, but given the context of Groff versus DeJoy, we do know that an increased burden on the workload of other employees, so the employees who were going to have to work on Sundays when the plaintiff was excused from work, that's not enough to show undue hardship under this new heightened standard. So our takeaway coming out of Groff versus DeJoy is that we have to look at requests for religious accommodation very carefully. We have to be a little bit more diligent in doing our analysis of what is an undue hardship. We now understand that it's more demanding than the prior de minimis standard. And of course, the main goal is to work collaboratively with the employee to find an accommodation that suits both the needs of the employer and the needs of the employee. So engaging in that back and forth and having that dialogue is crucial. Next slide, please. Now that we are post-vaccine mandate and we have the new standard for undue hardship as a result of the Groff decision, it's important to understand the way that these legal developments change the landscape of requests for religious accommodations. With respect to healthcare employers that decide to implement policies requiring employees to get flu shots or COVID boosters, it's important to understand that you have to look at the request for exemption from those policies with a little bit more care and diligence. As Adam highlighted, one of the main defenses that employers had available to them when the mandates were in effect is that excusing employees from the mandate requirements to become vaccinated was resulting in the employer's violation of law. The employer simply could not allow the requested accommodation because it would be in violation of the law, which is necessarily an undue hardship. So now that that defense is unavailable, given that both the state and federal vaccine mandates have been withdrawn, it's going to be really important to carefully analyze the facts of each situation and understand this new substantial increased costs definition of undue hardship in the context of religious accommodations. And I'm going to turn it back over to Adam.
Thank you, Hannah. Okay, so there are two more case studies that I wanted to talk about quickly, two more recent decisions that were in the healthcare context that I think are relevant for our discussion today. Next slide, please, Kathy. The first case came out of the Second Circuit Court of Appeals in November of 2023. In this case, the plaintiff was a male physician who asserted a gender discrimination claim under Title VII and the New York State Human Rights Law. It's a little unusual type of claim, but I'll explain how the plaintiff got to that allegation in just a second. So the plaintiff was terminated for poor performance and other issues. Shortly before his termination, however, there was an anonymous complaint that was made that the physician was abusive to staff. It was gender neutral. It didn't say that the physician treated men or women differently, but just generally said that he was abusive. During the investigation of that complaint, Human Resources obtained information that some people were making allegations that he discriminated against females. So that there was record evidence that this physician may have discriminated against females. The individual or the physician was not interviewed as part of this investigation, and he was terminated shortly thereafter. The physician claimed that he was terminated because of his gender, and he relied on, next slide, please, a unique theory that came out of a higher education case called Menneker versus Hofstra University. In Menneker, the Second Circuit found that there was an inference of discriminatory motive where there was a clearly irregular investigation following a complaint of sexual misconduct. But in Menneker, this was only where there was evidence of pressure on higher education institutions to respond more forcefully to allegations of sexual misconduct. In this particular case, the plaintiff acknowledged that there wasn't such pressure on the healthcare facility, but he said that the investigation was so irregular because he was not interviewed and because other people who he thought should have been interviewed were not interviewed, the investigation was so irregular that that in and of itself would give rise to an inference of discrimination. The defendants argued that that couldn't possibly be the law. Otherwise, you would have anytime there was a sexual harassment or sexual misconduct allegation, if the individual who was the accused wasn't interviewed, that in and of itself would give rise to an inference of discrimination and potentially sustain a discrimination claim under federal or state law. Luckily, the court rejected the plaintiff's theory and held that a clearly irregular investigation was not enough to support an inference of discrimination. So that's a good decision out of the Second Circuit in the healthcare context that's important to think about when you're doing your HR investigations. Next slide, please. The last case that I wanted to touch on briefly was another physician case. The physician, who was an Indian physician, asserted a race discrimination retaliation claim under Title VII in the Human Rights Law. Again, this physician was terminated due to poor performance and lack of peer relationships. He claimed that he was treated differently than a similarly situated white physician and that he was retaliated against after he made written complaints about the physician. I won't bore you with the details, but the court granted summary judgment for the healthcare employer. Next slide. And there were a couple of important principles that were reiterated in this decision. First of all, comparators have to be similarly situated in all material respects, which means that that comparator is subject to the same performance, evaluation, and discipline standards and engaged in comparable conduct. So in this case, the physician argued that the white physician was engaged in comparable conduct, but he had no evidence to support that assertion. He couldn't show that the white physician was subject to the same performance critiques or lack of peer relationship critiques. So the court rejected the comparator argument. The second important point that came out of this case was that it clarified to constitute protected activity, a plaintiff's complaint had to be sufficiently specific and include a claim that he or she is being discriminated on the basis of a protected characteristics. So in other words, this physician's prior complaints to HR that he felt he was being bullied were not enough to constitute protected activity that could then give rise to a retaliation claim, because he never said, I feel like I'm being bullied because of my race or because of my national origin. Because he didn't do that, because he was just complaining about, this guy's bullying me, that was not enough to constitute protected activity. So I hope that all of these cases and all of these updates were helpful for you. We look forward to seeing you at our fourth and final installment of this healthcare HR Bootcamp series, which is going to be on February 8th. You will all receive an invitation for that. We're going to be covering wage and hour issues in the healthcare context. So thank you all for being here. Thank you to Hannah for presenting, and we will see you next month.